Good afternoon, and welcome to the first day of our live webinar series, recognizing the growing economic impact of patent licensing. The purpose of this webinar series is to explain and highlight the important role that patent licensing plays in the U.S. economy and the U.S. innovation ecosystem. My name is Brian Pomper. I am the Executive Director of the Innovation Alliance, one of the co-sponsors of this series. Thanks to our other co-sponsors, the Licensing Executives Society USA and Canada, the Licensing Executives Society International, the Global Innovation Policy Center at the U.S. Chamber of Commerce, Autumn, and IP Watchdog. Now let me turn it over to Executive Vice President and General Counsel of Qualcomm, Don Rosenberg, for his virtual fireside chat with Director of the U.S. Patent and Trademark Office, Andrei Iancu. Thanks to you both.
Thank you, Brian. This is interesting, virtual fireside chat. We could go into all kinds of interesting conversations about that. It's really my pleasure. We only have a short period of time. My pleasure to introduce Director Andrei Iancu, who, as we all know, has served for the past 3 or so years as Undersecretary of Commerce for Intellectual Property and the Director of the United States Patent and Trademark Office. As both an engineer and a lawyer, Andrei has been a firm supporter of the patent system and has championed the rights of patent holders. A particular note, I would say, is Director Iancu's commitment to having the opportunities to invent and patent available to everyone. And as we today, in particular, honor the memory and legacy of Justice Ruth Bader Ginsburg and also recently Congressman John Lewis, I think it's particularly fitting that we start the conversation there. Andrei, on September 14th, you hosted the inaugural meeting of the National Council on Expanding American Innovation. The goal of the Council, as I understand it, is to build a more diverse and inclusive innovation ecosystem. Why do you see this as such an important issue? And tell us a little bit about it, please.
Yes, great. Thanks, Don and Brian and everybody else involved. And thanks for having me here on this program. Look, I think having broad-based innovation ecosystem in the United States where everybody can innovate and participate with equal opportunity is one of the most important things for the United States at this time and going forward. The fact of the matter is that I firmly believe that innovation can be the great equalizer or the great unifier of Americans behind the common national goal. It's always been like that from the founding of this country, and the constitutional IP system that we have. The bottom line, though, however, is that innovation is concentrated in the United States. It's concentrated demographically. For example, a PTO study recently showed that only about 13% of inventors nowadays named on U.S. patents are women, as just one example. It's concentrated economically, so we know from various studies that folks from economically underrepresented communities do not invent nearly as much as others. And it's concentrated geographically. We know the areas around the country where innovation takes place, the bulk of innovation takes place, places like Silicon Valley, Seattle, Boston, Philadelphia corridor there, the Research Triangle and the like, which is fantastic that those communities are so incredibly innovative. But there are vast swaths of the United States and communities across the United States that do not participate to the same level. And that's got to change. We've been making progress, but we really need to accelerate it for several reasons. First of all, for the individuals themselves, having the equal opportunity is great personally, as personal development, plus career development and economic development individually. We know that folks working in IP-intensive industries make 50% more in salary than those in the private sector who work in the other industries. It's important for the companies and the communities these inventors work in. We know the great benefits companies derive from innovation and IP protection and the like. Lots of statistics to that effect. And it's critically important for the United States. We're now facing competition from overseas, from everyone, when it comes to the innovation, of the technologies of the future. Everyone is innovating, from the smallest countries to the largest. And the bottom line is, we can't compete with one hand tied behind our backs. We need all hands on deck. So anyway, so this has been one of the main priorities of this administration. It's been one of my main priorities since I came in about 3 years ago. And as you mentioned, just a few days ago, actually a week ago now, we had the inaugural meeting of the National Council for Expanding American Innovation. This council is comprised of leaders from industry, academia, and government. And the goal is to help the USPTO develop a proposed national strategy, an actual document, a strategy that has input from all the various corners for the United States to expand the innovation ecosystem in this country, as I said, in all respects, demographically, geographically, and economically. So that's the goal. I know that your CEO, Don, is on that committee, and your president gave fabulous remarks at the event last week, and so have many others.
Yeah, I couldn't agree with you more. It is certainly the right time, actually. Time has passed for us to be thinking in this direction, but it's great that we're moving there now. And as you mentioned, it's extremely important from my company's perspective that we continue to encourage innovation and invention and the protections that are afforded by our patent system. Indeed, last week, to coincide with, or partly coincide, I guess, with the National Council's introduction, we have been leaders in a coalition that just started called Invent Together. It's a coalition of companies and universities and organizations who are dedicated to understanding the diversity gaps in invention and patenting, supporting public policies and private initiatives to close those gaps, and all the activities, including educating policymakers, practitioners, influencers about those patent gaps and the benefits to be derived, as you say, from patent diversity. And so we're happy to work hand in glove with you to make that a reality. It's been too easy an excuse, in my opinion, over the years to say, well, for example, there aren't that many women engineers, so that's why there aren't that many patentors. But that's just an imperfect excuse. It's not even a good excuse. Why are there fewer female engineers? Why is invention seemingly left largely to the male population? So as you say, I think we need to take advantage of the other half of our population, not to mention the other diversity issues that are so important as we continue this effort to expand. Let me ask you this. Certainly from my perspective, patents and licensing are essential to investments in groundmaking research and development. How do you see patents as that continuing enabler of innovation in our society, especially in this particular era where, as you indicated, there's so much focus and attention on development of innovation and competition, frankly, in throughout the world, and who's going to innovate first and best?
I believe that patents and IP in general are critically important to the economy of the United States, and for companies and academia and inventors, everyone who participates in the system. Not new, by the way. Our founders saw that from the very beginning, and that's why they included IP rights in the Constitution itself. And it really has been the engine of economic and human development for the past 200 plus years. Patents in particular, they serve multiple purposes. But some of the most important ones, first of all, they incentivize inventors and companies to take the huge risks that are necessary, both time and financial, to create something new. By definition, invention is, to create something that didn't exist beforehand, therefore unproven to a large extent. So that's risky enterprise. So to provide the incentive by promising exclusivity of rights for a limited time, that is and has proven to be very, very important. Second, it's an incentive not just to invent, but an incentive to disclose. That's what a patent is. The word patent means to lay open. So the idea is you do get, as an inventor, the protection of the patent, but at the same time, in exchange, you disclose it to the public. And that is so critically important because public disclosure enables the others to invent and improve upon your own invention, and to learn from what you have done, to know to stay away from what you have done, but in addition, to improve of what you have done. So this has created, in the past 200 plus years in the United States and worldwide now, this incremental yet exponential growth and the explosiveness of innovation that humanity has never experienced before. It's an absolute direct result of the patent system and this incentive to disclose. Third, the patent system creates, what I like to call a financial or an economic instrument out of an idea, which is by itself just, an idea, and from that, it's reduced to a document that it becomes an instrument for trade and for economic performance through your own practice of it. That's one example, but also for licensing. One of the greatest inventions of the American patent system was that it democratized innovation. Anyone could invent. You didn't have to be friends with the crown. You didn't have to be rich. And importantly, you didn't have to manufacture. In the old days, only the wealthy people with big factories were able to secure patent rights from the crown. In our system, anyone can do it. But if you cannot manufacture on your own, you don't want to, or you can't, or for whatever reason you're not doing it, it's really important to be able to allow others to do it, and that's what the licensing system enables. But you can't do that without this patent instrument that you have in the first place. Think about the university. Universities typically have great innovation going on, given the lab work that they do and so on. But they're not in the manufacturing business usually. What a shame it would be if all that innovation wouldn't be brought from the lab to the market. Having a robust IP system with this patent instrument enables that transfer of technology and knowledge to bring it out to the public. And that's just one of many, many examples.
Well, as usual, I couldn't agree with you more on each one of those 3 points. I particularly was interested in hearing you talk about the disclosure element here, because I so often find myself having to explain to people this is not a so-called patent monopoly that is just handed to the inventor and it's a prize. There's a social contract that's involved with it. And you know better than anybody how that inventor has to go through a process of disclosure, of very clearly defining the metes and bounds of his or her claims. And once you have established that social contract, The give to society, as you say, is that disclosure in great detail, and so that others can build on it as they have in the past, and that's certainly a very powerful element of our patent system. So a couple of things you touched on, I think maybe as the last or penultimate question I'd like to ask is so we're emerging, hopefully soon, at some day, we will be emerging from the pandemic. And I'd like to, I guess, have you expand a little bit on how you see patents playing a role in that emergence from the perspective of promoting economic recovery and the resiliency that we're going to need going forward.
Well, again, look, patents and IP in general are playing a huge role in technological development surrounding the pandemic and COVID-19, just like patents and IP have played in our history with respect to every other technological progress that we have made. So here in particular, we are making unbelievable progress when it comes to either treatment or vaccines, technology surrounding the pandemic. This platform, by the way, which is not medical, that we're using right now, this ability to do what we're doing right now just a few years ago was absolutely unbelievable. All of this is the result of the great technological development that came beforehand. The fact that we're talking about 300 plus or more vaccines already in clinical trials around the world as of right now, less than a year, several months only into the pandemic, is unheard of prior to this. So all this innovation comes on the heels of great technological progress and investments that have been made in the past, none of which would have been possible without the IP system that we have in place. Look, there are great incentives right now for various companies to invent and create a vaccine that go well beyond patent protections. No question. Everybody wants, for many, many different reasons, humanitarian in particular, to solve this issue. But all the tools that they have at their disposal is the result of great investments that have been made prior to this and continue to be made. I want to emphasize one point, Don, which is, as we are thinking about solving the current pandemic, we have to have at the same time our eye firmly on the crises of the future. The way we treat intellectual property right now in the middle of a crisis will be remembered as we necessarily have to prepare at all times and on a consistent basis for future crises that we cannot even predict right now. So IP must be protected and respected at all times, and especially they must be respected during a time of crisis. Because if IP is not respected precisely at the time when it is needed, inventors and investors in the technologies of the future will be less incentivized and less willing to take the risks needed to create the technologies that will help us get out of the crisis of the future. So there are many discussions around the world about the role of IP, but one thing must remain firmly in everybody's mind, which is IP and the promises that have been made surrounding IP must be respected. Of course, at the same time, we always have to achieve the appropriate balance, like with everything else surrounding IP, and make sure that there are no abuses and equal access is available as appropriate. But at all times, we must have the creator's rights in mind.
Well, on that note of the importance and how compelling it is to continue, as you say, in focusing attention on the IP system, innovation, and invention, I want to thank you for taking the time for this fireside chat. Maybe another time we can actually have a fireside next to us. And I guess I'm out of time. I'm going to turn it over to Brian now. Thank you so much again, It's been a pleasure, and I always enjoy our conversations, Director Iancu. Thank you again.
Likewise. Thank you, Don.
Thank you, Don and Director Iancu. Now let me invite the panelists to turn on their video feeds, and we'll turn to our first panel of the series, entitled Economists Discussion: How to Improve Data Methodology and Communication Around Patent Licensing. Note to our viewers, if you have a question you would like to ask the panel, please use the chat function. To use the chat function, click on the square box with Q&A at the bottom of the icons on the right side of your screen. Now I'll turn it over to the moderator for this panel, Brian O'Shaughnessy.
Thank you very much, Brian. It's a real pleasure to be here. This is such an important topic, and we have a great panel to address the many vexing issues that we're facing in the world of intellectual property and innovation today. So let me start with a few introductions. First, I'd like to introduce you to Carsten Fink. Carsten is the chief economist of the World Intellectual Property Organization in Geneva. He has held several academic posts, including Professor of International Economics at the University of St. Gallen. He has 10 years experience at the World Bank, both in Geneva as well as in Washington, D.C. His research focuses on intellectual property, innovation, and international trade. He holds a doctorate in economics from the University of Heidelberg in Germany and a Master of Science in Economics from the University of Oregon. Next, if I may, I'll introduce Nicholas Rada. Nicholas is the Deputy Chief Economist at the USPTO. Prior to joining the Patent Office, Nicholas did research at the U.S. Department of Agriculture's Economic Research Service, exploring science policy, food security, and agricultural total factor productivity. Nicholas holds a BS in economics and an MS in agricultural economics from West Virginia University and a PhD in agricultural economics from Oregon State University. And last but not least, Jonathan Barnett. Jonathan is the Senior Fellow for Innovation Policy and a Senior Scholar at the Center for the Protection of Intellectual Property. He is a Professor of Law at the University of Southern California Gould School of Law, where he is also Director of the Media, Entertainment, and Technology Law Program. He specializes in intellectual property, antitrust, and corporate law. And finally, if I may, I'm Brian O'Shaughnessy. I am a partner in the law firm of Dinsmore and Shohl in Washington, D.C., and I am also a past president of the Licensing Executive Society U.S.A. in Canada, and currently serving as the Senior Vice President for Policy for LES USA in Canada. So with that, I think we can go ahead and get started. And with a nod to the title of this webinar series, Recognizing the Growing Impact of Patent Licensing, I'd like to start off with just a question to our economists. What is the growing impact of licensing, and how is it manifesting itself? So perhaps start with Carsten. Carsten, you've seen it from both sides of the pond, being in Geneva as well as Washington, D.C. What are your thoughts on the growing impact of licensing around the world?
Thank you, Brian, and good evening, I must say, from Geneva. It's a great pleasure to join you all, and let me, of course, thank the organizers, Qualcomm, for having WIPO, or at least the economics part of WIPO, part of this discussion. Patent licensing, of course, is a really interesting phenomenon. It's something that we've always had an eye on. It isn't. We are going to talk about this, of course, something that is difficult to measure. And we very much like to do more work on patent licensing. But I think from all the evidence, that exists, we certainly know it is an important phenomenon, and I think by all measures, I think also an increasingly important phenomenon. There is a theory, if I can step back a little bit, about what are the boundaries of the firm. There's a very famous theory in economics that goes back to Ronald Coase, 1937, that asked the question: why is it that firms do certain things and not other things? What really defines the boundaries of the firms? And the theory that he advanced is that it all has to do with transaction costs and the ability to mediate with markets. So if, in a sense, it is cheaper for a firm to do things in-house, you do things in-house. But if it is better to mediate with markets, it is that is the preferable route. And that ultimately determines what companies do and what companies decide to partner with others. And that's where we get to patent licensing. I think patent licensing plays a really important role in the economy. It's a role that we probably often take for granted, but we probably should imagine a world where it wouldn't be possible to license a patent. Patent licensing is really important in enabling economic activities and enabling also innovation. Innovators may be good at innovating, but they may prefer others to manufacture. And they may also decide I'm going to manufacture in my own country, but in another country I'm going to partner with a firm because I'm not that familiar with that other market. I may also decide to collaborate in my innovation process with other firms, and as part of that, I want to share some of my technologies, so-called open innovation approaches. Or I may also, in a sense, try to transfer my technology to firms in developing countries that are at an earlier stage of development and who are still learning. All of that, patent licensing, the ability to license technology is tremendously important. We have some incomplete figures about this phenomenon, but I think whatever figures they are, they truly understate the importance of the phenomenon in broader economic terms, especially in enabling specialization in the economy that enhances overall economic efficiency. Let me stop here. I think there could be a lot more to be said about this, but I know I have very talented co-panelists who will say at least as interesting things as I hopefully will have said.
Well, I'll agree with you that we have some very capable co-panelists here. So with that, I'd like to turn to Nicholas. And Nicholas, you see this phenomenon every day from inside the patent office. Obviously, the growing impact of patent licensing couldn't be happening without patents. So what would you like to add to Carsten's comments?
Sure, thank you. I would just like to kind of underline Director Iancu's comment to the extent that the patent licensing is a facilitation of innovation, and to the extent that we have an acceleration of patent licensing, then that really reflects the culmination and the importance of these instruments in the economy as we build on each other, because the choice becomes do it yourself or share and innovate together. It allows in a form of specialization. If an inventor is not interested in commercializing the aspect, then that information can then be actors can specialize at different points of that innovation ecosystem or chain and work together to facilitate an invention to commercialization. So I think that more research. To me, this is an empirical question, and more research needs to be done. But I think this is a great forum to kick it off. And I'll seed from there.
Great, thank you, Nicholas. And so, Jonathan, you've seen this from a number of different angles, specializing in antitrust law, corporate law, as well as intellectual property. So what are your thoughts on the growing import of patent licensing?
Yeah. So let me, first of all, thank you for the opportunity to join this webinar today. And I'd like to build on the comments by Carsten and Nicholas and kind of bring us towards some of the valuation issues that I know we want to discuss today. And I think in whatever empirical project is undertaken, I think a key hypothesis to pursue is that the current numbers that we have on licensing income are most likely significantly understating the social value that is being generated by markets that operate through disaggregated licensing structures. And to illustrate this point, let me give you a concrete example. One of the most successful technology markets experiencing faster adoption rates than any technology ever invented is this device that makes things a lot easier. Might drive us a little crazy sometimes, but make things a lot easier. It's the foundation for Uber, for Netflix, for Lyft, Airbnb, and so forth. And how is that market developed? Well, it's developed through a licensing infrastructure that, along the lines of Coase's intuition, as Carsten was talking about, and a facilitative function, as Nicholas was talking about, it's bifurcated the market. What do we have at the top of the market? We have a relatively small number of firms that specialize in innovation. They then license that to all interested parties in the production segment of the market. And what has been the result of this? We get what I would call a market multiplier effect that enables entry both in the innovation side of the market, because you don't have to be forward integrated in order to monetize your R&D, but also importantly, it enables entry into the producer market because you don't have to be in R&D at all or not do very much of it. And what has been the result of that? Why is it that this technology has been adopted so fast by so many people? Because when you adjust for quality, the price has continuously declined from the inception of the market. Just think about it for a second. The computing power that you have in this device here is many, many times more powerful than the Apple IIc that I remember buying for about $1,200 in the early 1980s. Okay? Why does that happen? Licensing. Licensing enables the market to customize the supply chain so that every single actor is doing what they can do most efficiently, bringing down cost for consumers. I think this point is vital to explore empirically, because I think there's a misconception that a license is a tax and it inflates prices. The wireless market, which is one of our biggest technology success stories around, is just the opposite. Licensing enables specialization, it brings down entry costs, and that brings down prices. Thank you.
That's great. Thank you, Jonathan. So let me stick with you, Jonathan, for just a moment, because I know you've done some really interesting work in the area of how licensing and IP protection generally affects different industries, small enterprises and new entrants versus large incumbents who might be more well-heeled. What are your thoughts about how those various industries are affected by patents and licensing?
Yeah. So patents, I think we know, are critical for entities that focus on innovation and either do not have the capital or do not have the technical expertise to monetize it. I talked about the wireless industry, but let's move on to something else that I know Brian LES collects a lot of data on, which is the monetization of biotech R&D from the academic community. As Director Iancu talked about, that's actually one of your classic examples. I think it's almost empirically incontestable that the commercialization of academic biopharma R&D simply cannot take place without that patent to take the IP asset and put it inside what I'll call a property rights envelope. That property rights envelope then has not only the market multiplier effect that I talked about, it also enables that IP asset to get priced out in the market. Just like we see all tangible goods markets, we rely on property rights to get efficient pricing. Same thing in the intangible goods markets. Now, is that to say that we would have no innovation without secure property rights and secure licensing infrastructures? I will say something heretical, perhaps, in this webinar. I would say I think we would still see significant innovation, but it's going to happen within large firms that have their own internal information markets. You'll see firms like AT&T, but you won't see smaller firms. You won't see the next Qualcomm or the next Nokia coming into the market, because they simply will have no way to monetize their innovation if you don't have a secure licensing infrastructure.
Yeah, well, thank you. That's a really good point, and I appreciate the plug for LES's royalty rate and deal terms survey. LES is a big supporter of the Bayh-Dole Act. We think that has been incredibly influential in a most positive way in terms of getting innovation out of the academic lab and into the marketplace. And without the ability to transfer rights in an orderly way through the Bayh-Dole Act in a public-private partnership the way that it does, you just wouldn't see the kind of commercialization of some of those incredible groundbreaking technologies that, prior to Bayh-Dole just sat on a laboratory shelf somewhere. So I appreciate your insight and your input there. That's very valid, very valuable. Thank you. So, Carsten, let me turn to you now for just a moment. Certainly, the benefits that exist in patent licensing for the incumbent versus the small startup is not a unique feature of U.S. patent system. Is this something that you see in your international research as well?
Yeah, I would say so. What I might add to that is that of course, different companies have different business models. I think there is certain type of innovation, especially innovation that is relatively close to the commercialization stage, where I think size matters, and you need large companies undertake the investments to take products to the marketplace. I think that's most obvious, in the biosciences, to undertake these clinical trials. These are highly capital intensive, and you need essentially access to financial markets to fund them and so on. And to have large companies involved in that, I think that is also quite natural. I think it is also the case. There is a reason we have only, let's say, so many players in the smartphone industry, in a sense, to run a global operation, that commercializes the technology, that markets the technology. These are all highly scale-intensive activities. But there are at the same time, roles for smaller companies. And if one looks, and we did this 2 years ago, it's actually 3 years ago for our World IP report, for example, we looked at the value chain, behind the key smartphones. And if you see all the innovations that contribute to that, there are medium-sized companies, there are smaller companies that contribute to that. And I think you need both. Small can sometimes be beautiful. You may be a more capable, a more dynamic, flexible innovator. If you're small, you don't run such a large bureaucracy. But of course, there are limits to what you can do when you're small. So this is all to say that in some sense, patent licensing, serves both ends. And this is in a sense the beauty of patents. It's a very flexible instrument, and it really can adapt to different business models.
Oh, thank you. Yeah, and so Nicholas, what are your thoughts? I mean, does your research likewise show that the IP system and licensing in general contribute to sort of the great equalization, if you will, of the marketplace?
So the research that I've been, looking at has been mainly looking at how licenses facilitate knowledge flows, whether it be between countries or regions. And so I think, that's been the emphasis of, what I investigated mainly for patent licenses. And I think that's, incredibly important. And it goes back to my initial comments about being able to specialize at different points and facilitate innovation, regardless of what your position is as an inventor or a commercializer or where you may be.
Mm-hmm. Thank you. So, Carsten, let me come back to you for a minute, because your remarks sort of sparked something in my mind, which is, in the U.S., we hear a lot about how patent licensing, well, as Jonathan said, is a tax. Some people go further and say that it's a tool for what I would call unscrupulous business behavior. Is there a similar sentiment elsewhere in the world? Does that sort of argument carry any sway in Europe, for example? Or is that something peculiar to the U.S.?
Well, it maybe is something that is a bit peculiar to the U.S., and maybe it also has to do with the way the patent system, and in particular the legal system in the United States, operates. I would say that, certainly, and maybe, just to add to what Jonathan said, I think, especially from the perspective of consumers, characterizing license fee payments as a tax, I think is highly misleading. Obviously, you have to pay for the technology that you're buying. And I think, again, imagine a world where patent licensing wouldn't be possible and every company, were required to develop the technology in their products, on their own. In today's products, there's so many technologies that, this is simply inconceivable. And companies, they decide to focus maybe on, their core strategic assets and insource the technology that they need. And of course, that makes for really rich consumer products, that need to be paid for. And I think all the different, participants in this value chain obviously deserve their compensations. And that is also important, to maintain the incentives to innovate. I think, where the concern comes up a bit, of course, is in this business of non-practicing entity. And I at least get the sense, for example, that, in a country like Germany, there has been, concern, for example, in the auto industry that, car manufacturers are held hostage because, someone is in a sense, trying to assert a patent and is trying to assert a fee payment. That is potentially threatening to them in a sense that, may, especially the way German patent law operates, may threaten, the shutdown of car companies' operations. So these concerns exist. I wouldn't say, that, these are, I would say these are still, relatively specialized, specific concerns. And I don't think, they, in a sense, negate what I just said about the broader, benefits that patent licensing brings to economic activity.
I agree. You said, obviously, you have to pay for the technology that you acquire. I think, at least in some instances, we have the phenomenon, what I refer to as when you're the 800-pound gorilla in the room, the bananas are always free. So some entities don't believe that you always have to pay for the technology that you acquire. But anyway, Jonathan, let me turn to you again for a second. In your research, is there anything that you've seen that supports the notion that there is widespread wholesale abuse of the patent system or the licensing regime, such that it somehow calls into question the value of our patent system?
Yeah, so I think we, like any legal entitlement, a patent can be and will be abused. We can look at any area of law. But I don't think the evidence supports the view that that is the predominant phenomenon. I think the evidence supports the view that the predominant phenomenon is that licensing is a net value maximizing endeavor. It's bringing together a firm that has an IP asset with a firm that has a non-IP asset, and it's generating value. That's not a tax. Now, that again, to go back to my original observation, there are targeted steps that any field of law takes to deter opportunistic use of a legal entitlement, and the patent system has the tools to do that. I think the revisiting of the evidence, which by several researchers, which shows that there are a variety of entities that can be captured under the NPE rubric, some of which act opportunistically, arguably, some of which that are performing an intermediary function. And I think it's opportune to revisit the direction the case law has taken under U.S. patent law, under the interpretation of the eBay decision, which actually adopted the Kennedy concurrence. It did not adopt the concurrence by Justice Roberts and the late Justice Ginsburg, which had said that in general, the historical presumption in favor of injunctive relief should stand in special cases, courts should have the latitude to deviate from that injunction to address abusive practices. I think it would be time, given the empirical research that has shown that the NPE rubric covers a complex set of entities. I think it would be sensible to revisit whether the case law has moved in the appropriate direction in limiting so significantly the availability of injunctive relief under U.S. patent law.
Thank you. So let me follow up. You mentioned that there is a net benefit to the patent system and in particular patent licensing, as opposed to perhaps the opportunities for abuse. What sort of data is there out there that supports that, and what are they looking at? I mean, how do you measure that?
Yeah, there is a study by David Schwartz, Jay Keeson, and Chris Katropia, several studies that looks closely at the type of entities that could, under certain definitions of NPE, be captured by that definition. And what they find is in a nutshell, it's complex. There are some entities that may be acting opportunistically. But there are many entities that are transactional entrepreneurs. They are looking for ways to design structures to match holders of innovation assets with holders of production assets. I think there's a lot more empirical work that needs to be done. But I think the state of our knowledge at the present is that it's a complex question, and I think when we look at the total universe of licensing transactions, I think it would be unlikely to be the case, almost certainly not the case, that the NPE is the dominant type of business practice, right? If you look at the wireless market, that just couldn't possibly characterize a licensing infrastructure in which you have companies that are investing billions of dollars annually into R&D, and they're monetizing that through a licensing pipeline. That couldn't reasonably be characterized as an NPE. And so I think there is an opportunity and a need for empirical research to distinguish more carefully the extent of opportunistic type of NPEs from what I think is almost certainly the case, the much broader set of licensing entities that are adding value to the ecosystem. Thank you.
Yeah. Oh, yeah. Yeah, that's great. And that sparks a thought in my mind. I mean, the term NPE itself sort of is a bit of an oxymoron, if you will, in the sense that it's not as though they're non-practicing entities in many cases. Many cases they're producing a product, and the product is their IP. And the IP that they're producing and putting out there is inherently very, very valuable. It's making these complex devices possible. Any thoughts on that?
Yeah, I would refer the readers to some writing by Bowman Hayden, who has emphasized the point that as you move from a manufacturing to a services economy to a knowledge economy, what we need is a property rights system that allows knowledge assets to be exchanged, traded, and priced independent of any tangible product. And the policy challenge, and this is where we need the data to understand how to design the policy, is how do you enable that, which is almost certainly the predominant use of licensing infrastructures, while at the same time deterring, again, as is the case with any legal entitlement, the opportunistic abusive use of that entitlement. And I think that's the policy challenge that we have in front of us, to try and design the legal infrastructure for this sort of virtual trading market. And that's where I think empirical research and policy design could work together. And we do need more more data, which is not just quantitative, it's not just aggregating licensing income, but understanding what are the boxes, what are the different types of licensing relationships, and getting at least good approximations of the value that's being flowing through those boxes and the value that's being generated through them.
Thanks.
Thank you.
Nicholas, I know you've done some work as well, and what we ought to be looking at in terms of generating meaningful economic data for the effects of licensing and the IP regime on our economy. What are your thoughts about the things that we ought to be looking at and the challenges that we face in doing so?
Sure, thank you. I think the major thing to underline here is that from an economist's point of view, a patent license is going to provide a value for a given technology. And I think, at present, most of the research that's being used to inform policy is going to use patent counts, where they're aggregating all the patents. They're all of equal value, right? And we know that's not true. To capture innovation trends among firms or countries. Or patent counts could be weighted by, say, citations or how many countries that patent has been submitted to or filed in. And all of these are trying to infer some value out of that inherent invention. And at the end of the day, I think a patent license is the only form of information that's giving, a path towards appropriate economic comparison. Because when we aggregate up intellectual property, especially patents, and we know that they're highly skewed in their value, a small bundle could capture the large value firm's patent portfolio. So if we're going to be comparing firms, if you're going to be comparing industries or countries, then the patents themselves need to reflect the value that's being captured by, it could be society, could be the firm, but financial value is always taken a very center stage in economics because it allows for that pricing of information. And I think that's what would be very helpful to economic research to inform policy, would be getting information that would allow for appropriate weighting and therefore comparison of IP streams or patent streams.
Yeah, thanks. Your comments actually called to mind a story many years ago. At one of the LES meetings, I met a fellow who had recently left a rather notable company, and they had done a cross-license deal with another very notable company. I won't name either one of them, but they were in something of a nascent field at the time. They knew they needed to execute a cross-license. They didn't really know how to value that technology, so they literally brought in industrial scales and weighed their patents. So I think you might probably have difficulty with justifying that kind of an approach. It certainly seemed rather an odd approach to me at the time as well, but I think your points are very, very well made. So Carsten, what are your thoughts? What should we be measuring, and how should we be measuring them, and what are the challenges that we face in doing so?
Yeah, well, interesting example. If I could pick up on this, I think, one of the things we know about markets for technology is that they're highly imperfect. There are, to use the jargon, a number of market failures that characterize these technologies. So, one way actually to gain some insight about patent licensing, there have been several surveys of companies about their patent licensing activities. These are studies that were done in different countries at different points in time. And I think they obviously will always leave some questions open, but I think they allow for some insight. So I looked up earlier today. It was a really interesting study, a project by the OECD, which was concluded about 10 years ago, where they surveyed companies in Europe and in Japan, and they got a decent response rate of 600 companies in Europe and 1,600 companies in Japan. And, they found that 20% of the European patent filing companies actually engaged in licensing activities. In the case of Japan, the share was even a bit higher. But what I found interesting, and this is going back to the imperfection of technology markets, they essentially found that around a quarter of companies indicated that they have patents that they're willing to license to others, but they can't really identify any takers, any partners, who would, in some sense, be their counterpart. That speaks to, in a sense, the imperfection of the markets for technology. Matching, buyers and sellers there is extremely difficult. Every patent describes a different piece of technology. There's also, especially, at an early stage, as we know, a great degree of uncertainty about, how relevant patents will be, how markets will develop, what their eventual value would be. And, that's why maybe, weighing patents maybe considered, a way forward there. So, in a way, you could almost argue that, it's surprising how much patent licensing activity there is actually going on in the presence of these market failures. And, I think also we've come a long way. I think, there are, even formal markets for technology these days. But you could still argue, especially, if you take these figures of, in some sense, unrealized licensing potential, from 10 years ago at their face value, it does suggest, there's still lots of room for making these markets more efficient.
Thank you. So, you mentioned that it's an inherently unpredictable process. Is there economic data that we could or should be generating to streamline this process and make it more predictable?
Well, I think the short answer is yes. I think we are not starting off from zero. There's certainly, and there's some data available. There are some official statistics that are collected on licensing transaction. Almost ironically, we have more information available on international transactions than domestic transactions, and that has to do with the fact that countries have always made an effort to measure their external balance, their balance of payments, and as part of that, international licensing transactions, get recorded in many countries by central bank. In the United States, it's the Bureau of Economic Analysis that's linked to the U.S. Department of Commerce, and they do provide some interesting information on the international picture. Again, it's imperfect, it's incomplete, but I think, that's an interesting entry point. There are also, and in fact, I think that's sort of an underexploited source of information. Many companies in their financial statements provide information on their licensing revenue. And I'm not sure, I'm not aware of anyone who has tried to put that systematically together. And there have been a number of surveys. I think your old organization, if I may say, this autumn has done, I think, very useful survey work, and there's some information available through that. And as I mentioned, there are a number of academic studies, that are not repeated. I think they sort of give a one-time window into licensing activity. I think the great thing about these types of studies is that, they may not tell you that much about, how much money is flowing, but I think they tell you a lot about, what motivates firms to license their technology, what are, in some sense, how do they fit into their business strategies. And I think, that's quite useful and important to understand, their broader economic significance. But having said all of that, I think there certainly, is opportunity, to collect more information, especially as far as, I would say, private-to-private transactions go. I think there's quite a bit of information available from universities and public research institutes on how they commercialize their technologies, but on private-to-private transactions, I think there's much less information. Of course, one has to find, a way to collect this information, and maybe we can talk further about this in a way, that recognizes, this is in some sense a confidential business asset, and companies wouldn't just, to be willing to publish all of this. But I think, there are ways to collect more data that I think could enlighten us about this phenomenon.
Yeah. Well, you make a good point. I mean, you pointed out that Bureau of Economic Analysis, there's the Autumn Survey. We've also mentioned the LES Royalty Rate and Deal Term Survey, which does, in fact, reach out and catalog the private-to-private type transactions that you're talking about. The information, admittedly, is somewhat limited from an economic standpoint. It's really kind of more about pricing and what are the common terms and the stages of the deals. But it's a pretty useful piece of information. Nicholas, I know that you've done a fair bit of work at looking at the landscape. I'm sure many of our listeners would be very interested to know if there are other resources out there. Are there other things that you've found that have been useful in terms of picking apart the economic data and finding out what the impact of licensing is in our economy?
Sure. So I've identified, I guess, 4 different sources of data that could be relevant for this discussion. I mean, the first one would be private data for purchase. I've seen this used by various academics. There's a couple different companies. KT Mine is the one that I've seen used in academic research. And I have very little knowledge of this data other than it's privately accumulated and provided. I've not looked at the data myself. We then have, I would say, public access data of U.S. firms. And that comes in either a national or an international component. So the IMF actually provides international balance of payments information for every country along what Carsten was suggesting. It goes back to this international transfer. And these data have largely been used to look at knowledge transfers between countries from licenses. The BEA, as Carsten was suggesting, provides international licensing information or values, imports and exports among a multinational company to see the flow of technology within it, say from the US and out. And what I've been able to find about these data is that you have, it's the trade and services by type and country and affiliation, and you can get values for licenses on an annual basis, trademarks, franchise fees, for licenses to movies and TVs, books, recordings, to licenses to reproduce or distribute, computer software. But I think where this interest group finds the most consternation is the aggregation of licenses for the use of patents, industrial processes, and trade secrets. So BEA conducts this private survey firm private firm survey in the US, and it may be reasonable for them for disclosure concerns to guarantee that they're getting the most information available, that they're lumping up their patent with their industrial processes and their trade secret information. Now, this is only for the use of imports and exports of IP services. If one wanted to look at domestic information, then you switch over to the IRS. And the IRS has domestic royalties under their corporate source book and their tax statistics. They provide by size of total asset of a given firm, I suggest, but total royalties across all industries of domestic IP licensing. They found in 2013 we're nearing $200 billion of IP licensing in the US. And so then I think the fourth component one has to think about then about IP or patent licensing data would be what are the other sources, the public agencies, the universities? It's unclear to me the extent to which the IRS data or the BEA data is going to be capturing public agency patent licensing or patents that are licensed. I know the Department of Defense, the DOE, and HHS account for the vast majority of IP licenses in the federal government. We also have universities doing it. So it's unclear to me where one would find the most comprehensive data. I know the BEA data is probably some of the most informative when it comes to a given country's dissection of information. But, there's still the fact that we have to cobble together the international and the domestic and go to all these different sources could provide some frustration.
Mm-hmm. Yeah, and you've said before that, there's only so much government can do in terms of generating this kind of information, and that it's probably going to have to be an effort led by private industry because, first of all, they're the ones that are going to benefit the most from it. So how do you expect that sort of thing might unfold?
I would say, it largely comes down to the speed at which the process would like to unfold. I mean, public agencies, much like the government itself, is a very large ship, and to get it to change in any one direction takes time and effort, right? Now, if there is private sector effort and interest in trying to aggregate this information, collect this information, the fastest approach would likely be finding some third-party organization that has sufficient trust in parties that would allow for maintaining of disclosure and privacy, but that could allow for firms that are interested to submit a given technology bundle with a value in it. It doesn't have to be a bundle that's small enough to disclose any information, but it should be small enough that we can start valuing different parts of technology differently so that various insights could be generated. I mean, what the problem that one has with the government data is that it's not necessarily holistic for a given innovation or invention or type of firm that they're looking for. If one does a survey, you're picking up, you could call it random sampling of various sizes. An alternative strategy might be to if the private sector wants to motivate the public sector to change data recording of information, then maybe they should be the first ones to move forward and try to develop their own data set that is along the lines of what they're looking for. Do it in a way that maintains privacy and disclosure, but also puts everyone on the path of trying to get more information. And maybe once the kinks are worked out, then the federal government would see, hey, there's a lot of action in this space. The private sector has been clamoring for this. Maybe now it's time. But not seen very frequently in my life a public agency that's willing to move on just a request. Right? There generally needs to be a form of motivation and impetus behind it. And so I think that my intuition is that there's a lot of information out there on U.S. firms about the U.S., but that if firms want to move forward with rapidity, that they likely are going to have to try and develop that process for themselves in a way that is collaborative, that provides impetus for others to follow.
Yeah, good point. And certainly that was the underlying motivation, if you will, for the LES royalty rate and deal term survey. We're trying to get the industry to come together. We try to privatize and anonymize the data in such a way that nobody's really giving anything away. We use third-party vendors to collect the information. We see it as one of the principal values for our members that they get access to that survey information, but it's still not as robust as we'd like. So I very much appreciate your call to arms, if you will, for industry to lead this effort. And we certainly hope that people will join us and like-minded organizations that try to pull this information out and make it available.
I think
Jonathan, sorry, go ahead.
I was just going to say, I think, if you can get some larger entities to combine together, then you're going to get a better picture of what's going on in a market than you will from a survey. And I think that's just my intuition, but I'll leave it at that.
What do you mean? Well, you draw a distinction between a couple of the big players versus a survey.
If you have,
what's the distinction?
Well, if you're conducting a survey, then you're capturing a lot of presumably you're capturing smaller firms that are randomized nature. Whereas if you are able to capture a lot of the larger players, then you should be able to capture a majority of the market then infer the size of the market and start to get inferences about what is happening. Both are needed, obviously, but they give different insights, and different information can be obtained from both of them.
Yeah, interesting. Yeah, good point. Thank you. So, Jonathan, what are your thoughts about, if you will, the gaps that exist in the literature and the data that we have available today? What is it that we're not doing, and what are the challenges that we're facing that's making that difficult?
So I'll give some room for hope, and also identify some challenges. So I'll start with the bad news first. Yeah, I think it's an inherently challenging empirical exercise to value these licensing streams. We see that in the literature. There's both a collective action problem where we'd all like to know more about the licensing values, but no one wants to disclose their own transactions. Then the other problem is that we have just an apples oranges problem on a massive scale, where we don't have an easy way to standardize across patents, and as a result, I think Nicholas was referring to this. Even if you weight it by citation counts and so forth, it gets difficult. The third problem, I'm almost at the good news. The third problem is that the IP asset, the patent, for example, is often bundled with other IP assets, or what I would call non-formal IP assets. So very common to have a patent bundled with know-how. And so if you want to just find out what the patent value is worth, it's very hard, I think, to disaggregate that from the rest of the transaction, although it begs the question whether that's strictly necessary or desirable. Now, what's the good news? The good news is that I think we do have a fairly long history in IP markets of markets coming up, certain markets coming up with pretty good solutions to this problem. And those are the collective licensing organizations that have a very long history in the content markets, in the public performance rights for music, which have worked well for decades. They've gotten over the valuation problem by creating a bundle of rights, and so they aggregate across values without having to spend the transaction cost to identify the values of any specific asset. And more recently, I think we've seen good success starting in the late 90s with the MPEG LA pools and the DVE pool. Again, using these collective structures to try to get over these standardization and valuation problems. So there's both the kind of the top-down outside observer valuation exercises, undertakings are inherently challenging, which is not to say they shouldn't be undertaken. But I think it is also to look at what has the market been doing bottom up already to try and make these markets. And yeah, there are a lot of market failures, but there are some notable market successes as well.
Great. Thank you.
You're welcome.
So we've unfortunately come to the end of our time, but I think I'd like to take another minute or two and give you an opportunity for some closing thoughts. So, Carsten, let's get the perspective from across the pond, if you will. If you had the opportunity to talk to policymakers, what would be your final remarks about the value of patent licensing and why it's important to the global economy?
Thank you, Brian. Well, I maybe would end by what I said at the outset. I think from our understanding of the patent licensing phenomenon, we know it is an important one. I think that was reflected or try to highlight this by referring to some of the studies that have been done on the phenomenon. And it is of course the case that for the business models of certain companies, patent licensing are really important. And that is a global issue. Ultimately, technology is a global public good in a sense that, technologies are solutions to problems, and, problem, that is being solved in the United States, can also be solved in other parts of the world. And, that's why, companies tend to license things globally. And again, it's not only in some sense to enable international commerce in that regard. I think if one thinks about, the development dimension here, and, that may, sometimes be seen as a sensitive issue, because, technology transfer, ultimately is a good thing, because technology transfer enables, companies in poorer economies and developing economies to grow, to master technology, and that contributes to productivity growth in those countries. It becomes, of course, a bit sensitive, when those developing economies grow and, they start to compete in your home market. So I perfectly understand that. But I tend to ultimately think, this is a win-win game. It's something that promotes competition. It forces companies, to remain innovative, to in some sense maintain their competitive edge. And of course, we need patent protection to make sure that, companies also in an international context can earn a fair return on their investments to innovation. But, just saying this is not only in a sense about, commercializing products internationally, there is also, something in there that, can promote global growth or growth around the world, if you wish. I hope these remarks were sufficiently magnanimous, for me to end. But let me thank you, for having given me an opportunity to participate in this very interesting panel.
Well, thank you so much for joining us. We know it's late in the evening over there in Geneva, but we appreciate you taking your evening to spend it with us and share your thoughts. So, Nicholas, these are the products that come out of your office that we're talking about that are being transacted and exchanged. What's your perspective from inside the patent office? What would you like to share with policymakers, perhaps, about the importance of IP licensing?
I don't, well, Director Iancu was on here earlier. I don't know that the Patent Office necessarily has a vantage point on patent licensing itself, but from an economist point of view, I certainly see it as fundamental to getting any of these conversations started, because I don't think one can have a valid policy discussion if the measures one are evaluating are inaccurate. And I think inevitably that's what's the problem here. One must be able to compare accurate streams of data that are informative if we want to inform policy. And, I think that's just the fundamental issue of the day.
Yeah, couldn't agree more. Thank you. Thank you for joining us.
I would just like to say thank you. Thank you for having me. I appreciate the opportunity.
No, it was great to have your insights, and thank you so much for sharing them with us. And finally, Jonathan, I'll give you the last word. So, what would you like to say if you had, for example, some policymakers, the people from whoever the next administrations is listening in? What would you like to say to them?
Okay, thank you, Brian, again for the opportunity to speak. To kind of revisit some of the remarks I was making earlier, I think we've been on over a decade trajectory of IP policy and IP-related antitrust policy across almost all branches of government, with some recent exceptions among the antitrust agencies, which has progressively weakened the protections of patent holders. And what I would encourage policymakers to do is to look at the evidence. And I think many of the assumptions that drove those policy changes during the time we've had among empirically minded scholars or empirical scholars to look at that evidence, I think the world is much more complex. And specifically with respect to licensing, in markets like biotech and markets like wireless devices, I think the evidence is compelling that on net licensing is adding value. It's making the market more competitive. It's making markets and IP assets. It's enabling entry, and it's operating to the benefit of consumers. And that runs exactly contrary to this idea that IP and antitrust are inherently at odds. When you take another look at licensing as a value generator, it's actually a key foundation of competitive markets, just as it would be uncontroversial to say that property rights are a foundation for competitive markets in tangible goods. I think there's a robust theoretical foundation and increasing empirical evidence that the same is true to a large extent in tangible goods markets as well. That would be my message. Thank you.
Well, it's a great message, and thank you so much for sharing it with us. And thank you all for your time and your insights. It's really been a great conversation. With that, I'll turn it back to Brian Pomper. And Brian, I'll give you the opportunity for the very last.
Thanks, Brian, and thanks to our panelists for a great discussion. I hope you'll join us for the next panel in this series entitled The Economic Contribution of Licensing to the U.S. Economy on Thursday, September 24th at 1 p.m. Eastern. We have a great lineup of panelists, and I expect it to be a lively discussion as we had today. Until then, stay safe and well. Thanks, everybody.